Whenever we are speaking about intellectual property right, what strikes to our mind is how we are going to protect it. And protection cannot be a very easy way. There should be what is known as enforcement. So what do we mean by IP enforcement? IP enforcement refers to the act of protecting your intellectual property rights or assets. And it means that you are trying to stop free riders from causing harm to your intellectual property. You are trying to avoid losing the company's proprietary knowledge, and it could also mean that you are trying to solve the disputes with regard to ownership. Actually, somebody obtains confidential or private or proprietary information that belongs to you. It means infringement. So the word infringement means violation. That is violating your intellectual ideas or your creativity or your goodwill. So we need to enforce the intellectual property rights, or in other term we can say that we have to impose the IP rights. And this is possible by approaching the court of law by filing a case against the person who has infringed our intellectual idea or creativity. So this enforcement can be brought about this could be written by the right owner or the right owner's counsel, pointing out to the person to cease and desist from infringing in, and also giving a threat that if the person continues, that there will be action of infringement by law. So here you are writing a written letter to the person whoever is infringing your rights. And also you give a threat. That threat means here not violating the law. You are threatening him by telling that you will take the law to protect you against from whatever the other person is doing. Since it is a written communication, the person or the infringer has an option. He can either abide by the notice that you sent and stop the action, or the person can, if there are reason to do it, he will continue with the infringement. So you think like, okay, you have just sent the notice, whatever you want to do it, I'll go by my way. So that notice itself does not mean anything unless it is followed by the legal action. So simply sending a notice will not be helpful to you. You have to take a legal action. Now, why should you go for legal action is, see, you, as I told you, you cannot threaten any person. Or what will happen when you threaten, that person can in turn the situation to his side and tell that he has been threatened by you. Okay, and even you will fall in trouble. So it's better telling that we will take the law or enforce the law and stop you from doing such a thing. And the second enforcement is by the IPR office. So you have a patent that has been granted to you, and your competitor also files a patent making small modification around your invention, and the application is still pending before the patent office. So what you can do, you can use certain procedures in the patent office like pre-grant opposition and file an application before the patent office seeking revocation or cancellation of the right, which is still pending, because your objective is that if that right gets granted, then it will be hard for you to enforce your right, which is already in existence. So under these conditions, you can directly go to the IPR office. Once again, let me make it clear. Suppose say that you have a patent and it is being granted, and you come to a notice that your competitor is also doing the same invention or same design or whatever may be, but he has done it with slight modification, and he is also wants the patent, and still the patent is not granted for him. In that case, when it comes to your notice, what you can do is you can file an application. Okay, that is pre-grant opposition. Before granting the other person the patent, you can file an application of pre-grant opposition telling that whatever this person is doing is an infringement of the my patent. Okay, he has taken some modification from my patent. So what the patent office will do is it will not grant the patent to the other person, and we will see on the both the sides what is right and what is wrong. The third is intellectual property appellate board while filing a revocation petition. Now just let us assume that if the competitor's right is granted, the competitor filed a patent on a similar modification to your invention, and that is now being granted, and couple of years have passed and you have not come to its notice. Then later on, after a few years, you come to know that okay, your same idea, your same patent procedure has been slightly modified by the infringer, and he has been already granted the patent. So what you're going to do is you still have a remedy to challenge it before the intellectual property appellate board by filing a revocation petition. That is, you can go and tell the board that you want to cancel that person's petition who has modified your ideas. The intellectual property appellate board to correct the wrong which you feel could affect your chances of enforcing your IP. So by doing this, what happens is that if you feel that something is wrong, the appellate board will again check what has gone exactly wrong, and then it can cancel that patent which you think that it has been modified from your own inventions. Criminal and civil action. So, like both trademark and copyright attract criminal and civil sanction by the court. Then we have what is known as border measures. Like before going into border measures, I would like to tell that the civil and criminal actions, as I told you, both trademark and copyright can attract such type of punishment, whether it can be a civil punishment or it can be a criminal action. But in patent, what they do is a very important is whenever you are patenting your invention, you write a word known as claim. Okay, so what does this claim mean? Claim is a part of specification which, or after the patent is being granted, tells the third parties what they can and cannot be used in their invention. Okay, so you are claiming that this ABY is a procedure, and TDE is what I got, and so forth. So many claims you can make. Once the claim is made, only then you can file for the patent, and the patent will go for a thorough checking, and then you will be granted the patent. So what happens is when we told that if some other persons modify our invention, the patent office will look into your claims, whatever you have claimed, okay, and what the new party or whom you feel the infringer has claimed, whether it is same or not. So claim means that is you are telling the third parties what can and cannot be, you cannot do with the inventions. And lastly, we have enforcement through border measures. So border measures are with regard to import of an intellectual property. Say you have a patent protection over a particular technology and you find that a particular technology is not protected in uh, other country, maybe like a neighboring country like China or Nepal or whatever may be. And there the Chinese version of your technology which have been manufactured and which try to enter into our country. That time what you can do is we can go in for border measure telling that we have already have this technology in our country, but the other country has taken our technology and they have manufactured that technology in their country and now they are selling it in our country. So this border measure enforcement can also play a very important role for enforcing the intellectual property rights. So enforcement can be by cease and desist, that is a written letter or action before the intellectual property rights office or through the intellectual property appellate board, or you can take a civil and criminal action or by the border measures. So next comes what you mean by infringement. So infringement can happen in any of the intellectual property, whether it is a patent or copyright or geographical indicator or biological invention or industrial design or circuit designing. It can happen in anything. So infringement refers to the use of intellectual property without the permission or without the consent of the inventor. Now, the infringing acts can themselves be broadly classified as primary infringement, where the infringer directly infringes the act. The act of infringement is directly attributed to the infringer, or they could also be a secondary infringer. So, primary infringer is one, it is the first person, or it can be a secondary infringer, that is who supports the primary infringer. For example, if you have a design and your competitor also manufactures the same design without a patent protection, so he is becoming a primary infringer. That is, he has not patented anything, but he has copied your design and he is creating the same design, but he has not gone for patenting. And what he does is he supplies it and distributes it to different parts of the country with the help of the distributors and the retailer. So he has this distributors and retailers who are buying his product and selling it to the customer. So these person, whether your distributors or your retailers, they become what? Secondary infringer. And the person who's manufacturing that goods becomes a primary infringer. So the infringement can be either primary or it can be a secondary infringer. So a civil or criminal or administrative action can be taken against the infringer. And also another very important aspect in patent is the claim, as I said earlier, which has been granted protection and mapping the infringing act to the scope of claim, looking whether it fell with any of the rights of the patentee and also looking at whether there were any pertain to any of the exceptions. That is, as I told you, whenever you are going for a patent, you always claim so and so is what I have claimed, and that cannot be taken away by the third parties. So in turn you're telling that what can and cannot be done in the particular invention. So first, the patent office or the appellate board will look into the claim, whether your claim and the infringer's claim are same. If it is different, then you cannot say that that person has infringed your inventions. So the infringer is liable for punishment with imprisonment for term of which may extend to 2 years, and also it can have a fine, or in some cases it can be both imprisonment and the fine. So the case has to be filed where the defendant is, that is, where the patentee is resisting, or where the infringement has happened, and the court where that is where the infringement has occurred. So the claims of the patentee becomes very important in this case to tell that the other person has infringed my invention or my design or anything. So trademark, as we have already spoken, trademark, you have what is called as trademark search, helps to know if there is a similar trademark available, and it gives a fair picture of whether your trademark stands. Sometimes it also gives a forewarning of possibility of trademark ligations. So here what happens is, like, whenever you go for trademark search, it's better to go for a trademark search before registering to see that if the symbol or logo or the word is already present in any part of the world. Otherwise, what happens is that particular person who was the first person who to introduce that number or logo or that picture can he can action against you. So the first person is to file a trademark application at the trademark registry in India. So whenever you want to go for a trademark, you have to go for the registration in India. After the trademark application is filed, you pay some amount and then application is filed. Then what they do is they examine your application, and if there is any faulty or discrepancy in the application file, and this may take around 12 to 18 months. And next is the publication. That is, the step of publication is incorporated into the trademark registration process so that anyone who objects to the registration of the trademark has an opportunity to oppose the same. So what they do is, once your trademark, if the trademark office finds no discrepancy in your registration of your trademark, what they do is they publish. So that when it is published, the entire community or the entire world can come to know that what is your trademark. And if they find, okay, suppose say if I am in one country and the other country comes to know that, okay, this is the same logo what I have, then he can put an oppose. If after 3 or 4 months from the publication there is no opposition, then the trademark proceeds for registration. If no one opposes, okay, after the publication, they'll wait for the trademark office will wait for 3 4 months. Still, if there is no opposition, then you get the registration. So then next, what is registration certificate? Once the application proceeds for the trademark registration, a registration certificate under the seal of the trademark office is issued, telling that this trademark belongs to you. And you can go for the renewal of your trademark for every 10 years. So, like trademark infringement, you can see in this picture, okay, you can easily come to know which is original and which is the copy when you look into it deeply. Otherwise, you see that both somewhat they are same. So if these two marks they look identical or if they are descriptively similar such that it can cause confusion to the lay person, then infringement is determined and the mark should be with regard to goods and services. So you can file it before the district court or the high court, and the registered proprietor can file a civil suit. Any person can file a criminal suit for false description. A person can institute the suit where he resides or carries his business. Unlike patent law, there is no need to go after the defendant who could be in different city or in a different place. So here what happens in trademark infringement means you can be in your place itself and or where your business is going on, and there itself you can file a suit for the trademark infringement. Unlike in the patent where the you need to go and file where the actual infringement has occurred. So the punishment for trademark infringement, it is not less than 6 months of imprisonment and it can extend for 3 years, and a fine of 50,000 to 2 lakhs has to be paid by the infringer. Next, we have what is known as the copyright infringement. So, copyright, we told that it is an intangible right. Okay, it is the right which is granted to your intellectual idea or creativity of your mind. So, what is this copyright? So, you can't copyright an idea. So, we have what is known as a Copyright Protection Act and the Copyright Term Extension Act. And the protection is always automatic. Once you sign a copyright, it is an automatic that you acquire the copyright. So there is no registration required, though it is recommended. So given protection for life of the author plus 70 years. I told you has before, the copyright can be a book or it can be a recording or music or anything like this. And the author, life of the author, for example, the life of the author, say he at 60 years he passed away, but 60 years of his life plus 70 years he will get the copyright. Okay, and this copyright protection uh, is different in different countries. So sometimes protection for work for hire, what happens is that is I write certain article and I am employed under certain publisher. So what happens here, automatically the copyright goes to the publisher and not the author. And it can be for 95 years from the first publication or 120 years from the creation, whichever comes first. So infringement, as I told you, it is a violation of the intellectual property right when someone uses, makes or sells another trademarked or patented or copyrighted intellectual property without the owner's permissions, license or franchise. So infringement means it is violation and it involves all the things which come under the umbrella of intellectual property rights. So you can see that the punishment also is severe and it varies. So the penalties are actual or statutory damages in civil proceedings of criminal penalties for willful violation. You can go for a civil or criminal penalties, and generally the infringement requires proof. Okay, when you're saying the other person has infringed, it requires proof. The defendant has access to your copyright work. Okay, so whether that person whoever has infringed, does he has your work, or the defendant engaged in enough copying, that is, see, he may not be copying the entire book or entire music but part of it. Okay, Maybe willfully he knows that it is wrong, but still he does it. And that resembles between the allegedly infringing work and protected work could not be coincidental. And substantial similarity exists between the works. So if at all, if it is a fully copied or part of it is copied or some of things what copied exists between the two works, all these are called as infringement. But whenever it comes to copyright, there is a term what we call it as a fair use or defense or exception exists. Okay, when the copyright work or trademark is used without the property holder's permission. That is fair use means you are using the authors or the trademark person's certain work without his permission, and that is known as fair use. When you can use this, for example, in the education purpose. So the education is what we are spreading the knowledge. Okay, so there what happens, like whenever I am speaking, these are not my ideas. I have taken it from the books, okay, of some authors, and I'm explaining and putting it in the form of PPT. To some extent, this is allowed because I'm using it for the educational purpose. Otherwise, how can that knowledge be disseminated? How can I get the knowledge, and how will you get that knowledge until I teach you all and I get learned from that book? So this is known as a fair use. So it can be for the purpose such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research. That is, if you are doing some research, you have to do a literature survey. Okay, how much of work has been done in that particular research, and you quote that particular author that you have taken this from this author, and the purpose and the character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyright work as a whole, and the effect of use on the potential market for copyrighted work or on its value. So this is known as the fair use. Trade secrets. Sometimes even the trade secrets can also be infringed. What do you mean by trade secret? Trade secret is any secret formula, pattern, process, program, device, method, technique, or database used in the owner's business that gives the owner competitive advantages. So these are the trade secrets which the owner keep it as a secret so that he can grow in his business without letting his secrets out. A firm must make a reasonable measures to maintain the secrecy. Okay. So what happens if, see, if a product C is being made by a company A and B, maybe that product is different what A is making and what B is making. Okay. The process of making it is different. So suppose say the product what I told you C, all the consumer likes what the A makes is, that means he's having some secret ingredient in it that is making that product C unique from that of the company B. So a firm must be reasonable measures to maintain the secrecy. So here also what can have happen is there can be a leak out of your secret. See, if you are handling your company alone, then the secret can remain with you. But if it is a big company, what happens? Your employees will know about the secret. So misappropriation of trade secret occurs when a person discloses or uses after acquiring the secret. So somehow the secret is known and he discloses it to the other company. That is wrong. By improper means, that is, they can either by theft or by trespassing, etc. By other improper means, they can acquire your trade secrets either by threatening you, or if you have any written documents of that particular ingredients what you have made, taking it away from you without your knowledge, or through another party who is known, or should have been known to have obtained the secret by improper means, by breaching a duty of confidentiality. That is, what should be kept confidential, it is not kept. That is called as the breaching. That is, it should be between you and me. But suddenly, what happens? You leak out the secret. So you have breached me. Okay. So trade secrets can also have this infringement. So now, lastly, like why should you go for the license? Okay, a license agreement can be viewed as serving three primary purposes. To effectively address each of this, it is critically important that the parties understand both the overall objective of agreement and more specific objective each party has in entering into an agreement, especially in combined research and development and licensing deals. So defining the scope of right between transferred between the two parties, okay, defining the compensation for those rights and putting a structure for managing the risk that each party takes on in carrying out the agreement. So whenever there is agreement, it is always best to go for the license agreement. So license agreement comes under the term of law or court. So anything tomorrow, if it goes wrong, you can fight in the court, and the court will have all the evidence to support you against the infringer.